termination of subject matter, death of the party, change of law, cessation of state of things, a declaration of war. So these are the ways by which a performance cannot be fulfilled or executed or cannot be enforced at all, because that was impossible to perform subsequently by maybe there may be many reasons, and some of the reasons may be destruction of the subject matter or death of the party or the declaration of war, cessation of state of things, or change of law. So we'll just go into it. So if a particular terms of the contract impossible, it can be initial impossibility and subsequent or supervening impossibility. Suppose a person have decided for a concert in a particular hall, and that hall get destroyed by fire. So there's a destruction of subject matter where a particular performance could not be done because of the destruction of subject matter. That is a supervening impossibility. And someone have decided to have a concert, and he's a pianist and he want to play piano, but while during the time of his journey, he met with an accident and his hand is amputated. So that too, he could not, he might have, the accident, he might have expired too. So death or some sort of impossible situations or circumstances made him to perform that particular concert, then that would result in the supervening impossibility. And another is the cessation of state of things. That is, suppose one decided to marry another. Just before 1 week of the marriage, the other person became unsound. So that's a cessation of state. Neither is change of law. Suppose one decided to give the property to another, but later on, the government have acquired that property. It's a change of law. So here, that particular property has been acquired by the government. So that is also that particular contract cannot be performed. And if the earliest instance, or if there's a declaration of war, all the particular terms of the contract cannot be performed. So these are the ways by which a subsequent impossibility arrives and which lead to the termination or discharge of contract. And there may be some instance where there is some difficulty to perform, or some commercial impossibility, or there is a default by a third person, or there is a partial performance of the contract, or there you could say some strikes or lockouts or something like that which resulted in non-performance of this contract. So these are not a supervening impossibility at all, and you cannot consider that is having impossibility. So just you have to just go into it. That is, if there is only a commercial impossibility, or there is some sort of very difficult situation to perform, or if there is a strikes or lockouts or something like that, or if it is a defect or default by a third party, or some, so, or you can partially, you can perform the contract. So that all won't amount to any supervening impossibility. Okay. And another instance is a discharge by breach, as we all know. Then there is a particular terms of the contract, and if you are not able to perform according to the terms of the agreement, you could say that there is a breach of contract. There is an actual breach and anticipatory. So the breach can be classified into two: actual breach and anticipatory breach. This actual breach, if I have decided to give goods to Sarah, and if I'm not giving that goods at that particular day, particular time, so what? That's an actual breach. If I want to give some goods to Sarah today, I know that I'm not going to give that goods. I'm not going to deliver the property. So before the exact day, or today is the day for which I have to deliver the goods. So before this, or before today, or just day before yesterday, I've given the information that, Sarah, I'm not going to deliver the property, or that I'm not going to deliver the goods. That is an anticipated breach. So this is actual breach and anticipatory breach. So before the day of that performance, you are just informing and you know that you are not going to perform the terms of the contract. That is anticipatory. So these are the two modes, actual breach as well as anticipatory breach. So these are the modes by which the contract gets discharged or the contracts get terminated. So by performance we have studied, actual and attempted. Another is by mutual agreement, novation, rescission, remission, alteration, and the waiver. And by lapse of time, as we all know, another is by operation of law, by death or insolvency or alteration, merger. These were the things. And by impossibility of performance. By impossibility of performance, you already studied. It can be initial as well as supervening. Supervening by the distraction of subject matter, or the death of the party, or change of law, or cessation of state of things, or declaration of war. Another instance all would amount to the supervening possibility, and by breach is actual breach and anticipatory breach. And also we can just discuss of also the remedies with regard to this breach. It's a very short topic. Let me convey to you. Yes, it's a small topic. Can I continue? Yes or no?
Yes.
Okay. So, as we all know, there is a maxim: who preaches, it be remedy. Where there's a right, there is a remedy. Who preaches, it be remedium is a maxim we all have studied. Wherever there is a right, of course, there can be violation. And for the violations, there is a remedy. So with respect to the terms of the contract, when there is a breach of a contract, we have the remedies. How are the remedies to be executed? So there are various remedies. One of the remedies is the rescission of the contract. Another is sued for damages. And the third is sued for specific performance. And fourth is sued for injunction. And the last is quantum merit. So these are the 5 remedies where we can approach or we can sue for the breach of the contract. So the first instance is, as you all know, rescission of the contract. Another is sued for damages. The third is sued for specific performance. Fourth is sued for injunction. And the last is quantum merit. The first thing is rescission that you've already discussed. Suppose we are breaching a contract, or the performance of the contract cannot be done. The parties can cancel the contract. That is a rescission. So rescission is cancellation of the contract when there is a breach. So the breach of the contract, you can cancel it. Another mode is sued for damages. As we all know, damages means compensation. With regard to the tort as well as contract, you know, in the case of contract, it is liquidated damages that is already fixed by the parties when they are entering into the agreement. So the damages can be classified as general damages, special damages, vindictive or exemplary damages. So these are the damages. As we all know, you know what is damages or compensation. So general damages means, as a general, when there is a breach of contract, the parties are agreed, or liquidated damages, as we said, the parties are agreed that we'll just, when there's a breach of the contract, we'll pay the compensation. This amount of compensation is fixed between the parties. So it is a sort of liquidated damages. So if it's in general terms, that is a general damages. If it is actually the special circumstances are there with respect to the terms of the contract, there we can say that it's a special damages when there is a breach. Another is vindictive or exemplary damages. That you can say that causing some mental agony or a mental harassment as there is a breach of contract. Due to the breach of contract, some emotion or mentally gets harassed or mental agony is caused to the party. Main thing is some of the examples I could say that when there is a breach of marriage, there it is a vindictive or exemplary damages or compensations given when there is a breach of marriage. Another instance is where at the time of the disordering of the check without any lawful means or ways, or where there is a dishonor of check by the party unlawfully, there it is also causing a mental agony to the reputation of the customer. So there the damages is of course a vindictive or exemplary. And there is nominal damage. Omega, there may not be any sort of, there's a need of what you call damages, but we are just giving for the type's sake, for the name's sake, omega damages or compensation. There may be some instance where the goods gets deteriorated or decayed by lapse of time. So there we are giving damages for that decay or deterioration of the particular goods by lapse of time. So these are the damages or different types of damages. So liquidated damages is already fixed by the parties. General damages, then special damages, vindictive damages, and nominal damage as damages, and another is damages when there is a decay of the articles due to delay. So these are different kinds of damages. So another aspect with regard to a suit for specific purpose. There will be some instance where the monetary relief is inadequate. Amount or compensation is not adequate in particular instance. Suppose Mercina and I have entered into a contract just to purchase some antique collection, which is very rare. So money or compensation, the amount or monetary compensation is not at all adequate. I need that particular antique collection. So in such circumstance, a suit can be filed for specific performance. That is to have that particular property. And if the court cannot actually have a monitor upon this particular terms, and that particular contract is of something like a personal nature. Suppose I want to get a particular house because it's having such a good view. The surrounding is actually full greenery, and I need that particular site alone. So even if the amount is given as compensation, it is not at all adequate for me. In such instance, I can sue for specific purpose. Another is sued for injunction. Injunction is if I'm having a positive terms of the agreement, if I'm doing it negatively, so the court can restrain from me from doing that negative act. Simple example, I've decided to have the electrical works from particular company for my new house. But later on, I am just going to purchase the electrical works or the equipments from some other company. Then the court can actually restrain me from purchasing from other company. That is sued for injunction. And the last is quantum merit. Quantum merit, the word meaning is as much as. When I just give an illustration, it will be very easy. I had decided to give 12 articles for publishing it in a magazine. I've written 6 articles and I've given to that magazine. Later on, the publication of that magazine was discontinued. But I am entitled for the amount to buy 6 articles. That is as much as I've earned. So that is with regard to quantum merit. So as much as I've performed the terms of the agreement, I'm entitled for that particular reward. I'm entitled for the reward for that particular performance of my terms of the agreement. So that's quantum limit. So these are the remedies of the breach of the contract. So that's all. And if you have any doubts, just ask me some questions.